proponents. When the Attorney General and the Governor refuse to defend measures passed by the people, they effectively nullify the will of the voters. This sets a dangerous legal precedent and is manifestly unfair to supporters of a successful initiative. SB 5 would grant standing to initiative proponents in California courts, codify that initiative proponents are persons who submit a draft of a petition proposing a measure to the Attorney General with a request that the Attorney General prepare a title and summary of the main points of the measure. Currently, courts have sole discretion as to which parties can intervene in a case challenging the initiative. This bill would make that intervention a right, not a courtesy under the law. Today, I'm pleased to have with me today to testify in support of the bill John Eastman, a former dean of the Chapman Law School in Orange County and a nationally recognized constitutional expert. I'd ask for permission for Mr. Eastman to testify.
Mr. Eastman, welcome.
Thank you, Senator. I'm delighted to be here today. You know, this year marks the 100th anniversary of voter approval of amendments to the Constitution that added the powers of initiative and referendum and recall. As a political science professor Ed Erler at Cal State University San Bernardino has noted, and these devices of direct democracy were designed to allow the people to take action in the face of government that was either unwilling or unable to serve the public interest. Other states have the initiative now, but none have it as strongly as California does. That's because it grew up here. Governor Hiram Johnson put it into effect, and when he did so, he said it's going to return the government to people and to give them honest public service, untarnished by corruption and corporate influence. He then authored Proposition 7, which led to the initiative provisions, Proposition 4, which gave women the right to vote, and Proposition 8, providing for recall. These things gave citizens techniques to check the influence of special interest groups, alter the state's political agenda and public policies, and remove unresponsive or corrupt office holders. Now, it's important to recognize how important that initiative is and the history of it. And given all of that, it should be no surprise that the California courts routinely allow initiative proponents to intervene in litigation challenging the constitutionality of the initiatives that they have successfully sponsored. In fact, the California Supreme Court, recognizing a concern when elected officials won't provide a vigorous defense because of their underlying opposition to the initiatives, that it would be an abuse of discretion for the lower courts not to allow intervention by the proponents of the initiatives. It's for this reason that Justice Malcolm Lucas has called the initiative not a right granted to the people, but a power reserved by them. And it's one that it is the duty of the courts to jealously guard. This is a judicial policy, therefore, to apply a very liberal construction to the initiative power. Permitting intervention by initiative proponents under these circumstances, he concluded, would serve to guard the people's right to exercise the initiative power, a right that must be jealously defended in the courts. Now, as I said, we've seen a number of cases where the California courts have routinely allowed intervention by initiative proponents, even while denying intervention to others who were merely supporters of an initiative. The courts have treated them as indispensable parties, as aggrieved parties. And so if left to their own devices, I think it would appear that our courts in this state have provided ample authority for initiative proponents to defend their own handiwork and thus guard the fundamental right that our Constitution gives to the people. But increasingly, initiatives adopted at the ballot box by a majority of Californians are being challenged in federal rather than state court. And the authority that the state courts have given for them to intervene is not necessarily coterminous with the authority that the federal courts have to recognize their standing to defend their own initiatives of their own. Now, I think in California law, we have given them the prime special place that should allow for federal court. But this bill, I think, would just bring that home to make sure that any initiative that is passed by the people of this state, even when the Attorney General or other elected officials choose not to defend it, would get the kind of day in court that the initiative desires. Now, I want to make clear that this bill is simply clarifying what the California Supreme Court has already acknowledged, that it would be an abuse of discretion for lower courts to deny intervention by initiative proponents in litigation challenging the constitutionality of the initiative they sponsored. Finally, let me add a brief word about the politics of all this. The importance of this statute in defending what the courts have called the precious right of the initiative that the sovereign people of the state of California have reserved to themselves should not turn on the partisan correlation of support for or opposition to any particular initiative. This bill would allow proponents of initiatives from across the ideological spectrum to defend the initiatives they sponsored when the elected officials of the state choose not to do so. To be sure, a couple of recent examples of initiative that had not been defended by the Attorney General, Proposition 8 defending marriage and Prop 187 dealing with illegal immigration come to mind, may have found more favor among Republicans and Democrats. And because the last three holders of the office of Attorney General have been Democrats, it's probably no surprise that those Attorney Generals were less than enthusiastic in even wanting to defend those initiatives. But the shoe can just as easily be on the other foot. In fact, it currently is elsewhere in the country. In Washington State, Attorney General Rob McKenna, a Republican, has declined to appeal an adverse trial court decision against the Land Commissioner and the Department of Natural Resources. And the Republican Attorney General in Wisconsin, J.B. Van Hollen, has refused to defend that state's domestic partnership law against a claim that it violates the marriage amendment to the state's constitution. Here in California, the variety of policy decisions now made by initiative almost guarantees that at some point the ideological lines will be reversed. But the failure to defend concern can also arise with respect to statutes adopted by this legislature. Imagine a regulatory takings challenge to AB 32, for example, that a Republican Attorney General might refuse to defend against. Or a First Amendment challenge to Proposition 65 on the grounds that the warnings mandated by that initiative are compelled speech in violation of the First Amendment.
Mr. Eastman, I don't want to rush you, but at the same time, I don't want to
I've got 2 sentences left.
Other witnesses have at least more than 30 seconds.
I've got 2 sentences left and I'll be done. Or a challenge to Proposition 103 on the grounds that the automobile insurance rate reductions mandated by that initiative were an unconstitutional taking of private property. Or finally, a challenge to Proposition 34 on the ground that stricter limits on campaign contributions contained in that initiative violated the freedom of speech. As you might see, the opportunity for mischief is as broad as the imagination. As I said, the California Supreme Court has already recognized that denying intervention by initiative proponents would be an abuse of discretion by the California courts. This bill would confirm that such intervention is a matter of statutory right, thereby confirming that initiative proponents can also defend the precious right of the people to adopt initiatives, even in federal court. I strongly urge its approval.
Thank you, Mr. Eastman. Others in support?
Catherine Pettibone with the Civil Justice Association in support of this measure. We believe, similarly to the previous speaker, that currently courts already allow this. This bill merely codifies the practice of allowing proponents to intervene as interested parties. The initiative and referendum process is reserved. It's a power reserved by the right of the people and should be liberally construed. We think this bill furthers that, and we urge your support. Thank you.
Thank you.
Good evening, members. My name is Pablo Cibaja, Legislative Director for Capital Resource, and we're also in support of SB 5. I'd like to present to you a scenario should Proposition 19 have passed. We currently have a governor and an attorney general that were opposed to Proposition 19. That was the legalization of marijuana. If it was challenged in the courts and found unconstitutional, then the possibility that our current Attorney General and our current governor would have refused to defend that law would have obviously disenfranchised voters who would have approved that proposition. So setting politics aside, I think this is an important measure. If we look at it from an objective point of view, this, as was stated, codifies current law, and I think it would be beneficial for the people of California to have an opportunity to have a say in terms of their proponents of propositions approved by the very people that you all represent here today. So for those reasons, we strongly urge you to support SB 5. Thank you very much.
Thank you, sir. Anyone else in support of Senator Coleman's bill? Not unless the opposition come forward.
Good afternoon, Mr. Chair, members of the committee. Mario Guerrero on behalf of Equality California. We're here in opposition to SB 5. SB 5 would force the courts to accept proponents of an initiative as interveners in any state court case challenging the initiative's constitutionality, has been said. Existing law properly gives the Attorney General, as the state's chief law enforcement officer, the authority to defend challenge state measures. Under existing law, initiative proponents have no automatic right to participate in cases challenging an initiative measure, although a court can and often does grant them the ability to intervene in a particular case, if appropriate, and when the state is also involved as a party. SB 5 would therefore constitute a dramatic, unwarranted, and harmful departure from existing law. Unlike the Attorney General or other state officials, initiative proponents are not elected or accountable to the public. The only requirement necessary to become an initiative proponent is to submit the text of a proposed initiative and to obtain sufficient petition signatures to qualify the measure for the ballot. Initiative proponents do not stand for election and do not swear an oath of office. They have no responsibility for stewardship of state funds, including the expense of representing the state in litigation, including awards for attorney's fees that could fall upon taxpayers to pay. Proponents also have no statutory responsibility for the administration and enforcement of an initiative after it has been adopted, and therefore no responsibility to consider and balance the benefits, costs, and burdens to the state of differing enforcement policies. Equality California opposes this attempt to limit the proper authority of the judicial branch to determine who are appropriate parties in cases challenging the constitutionality of state enactments. We respectfully ask for your opposition vote.
Thank you, Mr. Guerrero. Others in opposition?
Yes, Mr. Chair and members, Ilona Turner, staff attorney with the National Center for Lesbian Rights, in opposition to SB 5. This bill would permit initiative proponents to intervene in any suit challenging the constitutionality of an initiative, and this would dramatically change the balance and the separation of powers mandated by the California Constitution by giving unelected private individuals unchecked power over litigation and legal policy decisions that are presently vested solely in the Attorney General. Unlike the state's Attorney General, initiative proponents have no duty to broadly represent the policies and interests of the state in the many legal matters in which it's involved, and they might not share the state's interests regarding, for example, which matters should be pursued on appeal, given the possibility of precedent that might be binding in future matters. Initiative proponents, as unelected members of the public with no term of service or oath of office and no accountability to the voters, lack any responsibility to balance the many competing public interests that may be implicated in litigation challenging an initiative, including the state and federal constitutions, or to balance the interests of different constituencies throughout the state. This proposed change would intrude on the Attorney General's responsibility as the state's chief law enforcement officer, jeopardize the public interest, and violate the fundamental principles of standing that are essential to the fair and rational functioning of our judicial system. For these reasons, we urge your no vote on SB 5. Thank you.
Thank you, Ms. Turner. Anybody else in opposition to Senator Harman's SB 5? Questions from the committee?
Well, yes, thank you, Chair.
Please.
I guess I've always grown up believing everyone should have their day in court. Our system of justice is such that even those who commit the most heinous crimes, who are obviously guilty by every measure, is due a day in court with adequate representation. We agree to that, I presume. Why wouldn't that same opportunity for a fair hearing of both sides of an argument be made available for an initiative?
Is that rhetorical or directed to one of the opposition?
To those who just spoke in opposition. I'm just trying to better understand the logic. Or is this a different situation where initiatives aren't persons and so the court system sees it different? It just seemed a basic concept of fairness that there should be that day in court and both sides should have opportunity for representation.
Well, I'll respond to that. Under the current law gives courts in the first instance the discretion to decide whether or not to allow intervention, whether a party seeking to intervene has standing, has enough of an interest in the matter before them to warrant being heard before the court. And our Constitution gives the state's attorney general, gives the executive branch that authority, the authority to defend statutes and constitutional amendments, and to decide in particular cases whether a defense or an appeal is warranted, and balancing all kinds of policy and other factors. And so this, we think that that's the right approach. That current system should be preserved.
I guess with the indulgence of the chair, my concern is the whole purpose of recall referendum and initiative under Hiram Johnson back in 1910 was to get around the elected class that was largely in the control at the time of political parties and the railroad. There is a belief that that system was potentially so immune to internal reform, there had to be some ability for the people to circumvent these powerful political forces who have taken oaths of office and have received campaign contributions or have certain philosophical views. So it seems to me that the author of the bill is, A, only ensuring that both sides are adequately given opportunity to be heard, and B, to preserve the intent of recall referendum and initiative, that the people would have a vote. Maybe Mr. Eastman can speak to that sentiment. That it seems obvious to me, but maybe I'm missing something.
No, Senator Blakeslee, I think you're absolutely right. There's a statute that says the Attorney General has the obligation to defend all causes to which the state is a party. The issue is what happens if, for political reasons, he chooses not to. The initiative was designed to allow the people to end-run government officials when they were being recalcitrant. The notion that we would then allow that very same elected official that the initiative was designed to get around to effectively veto the initiative by not providing any defense in court, and it doesn't matter what initiative it is, whether it's environmental or consumer protection or anything. The notion that we would hand a veto power to the Attorney General simply by refusing to defend the initiative is bizarre. And I think this bill acknowledges what the courts have recognized, that because of the importance of the initiative, you have got to allow the initiative proponents to weigh in, particularly when the government officials responsible for the defense are not doing so with vigor or at all.
Thank you, Mr. Eastman. I don't know that the Attorney General actually has veto power. It's still in the discretion of the court. But Ms. Turner, you got a comment?
I'll just add that the initiative power, as enacted by the people of California, is a legislative power only. It was not intended, and does not say anywhere in the Constitution, and never has, that the proponents of an initiative measure are also granted executive power to defend a measure in court, and that is not something that the people have ever voted on. If proponents of a measure wish to allow that power, grant themselves that power, they are perfectly able to put that into the text of the measure and allow the voters to vote on it. But if that is not the case, then there's nothing in current state law that gives them that right.
Are you suggesting that this should be a constitutional amendment as opposed to a statute?
Yes, we think that this measure invades the separation of powers that is set forth in the California Constitution.
Very good. Thank you, Senator Blakeslee. Senator Harmon, my concern, and I have a consistent concern with any attempt to limit the discretion of the judiciary. And so given that the judiciary has that discretion, I understand you're trying to solve a problem. What I haven't heard from you or from Mr. Eastman, and what I'd like to ask of you is, could you cite your 3 top examples of that abuse of the current discretion that's allowed?
I think I'd defer to Mr. Eastman, if you wouldn't mind. He cited several in his comments. Perhaps, Mr. Eastman, you could help.
Just asking, do you as an author have 1 or 2 or top 3?
Top 3? That have already occurred? Or
where the court has abused its discretion?
Well, certainly I would point to Proposition 8 was probably the most recent one, Senator Leno, where I think that that would have happened. I think in Prop 187 was another one, and those are the 2 that come to my mind. As I say, Dr. Eastman did refer to several in his comments. I'm sure he's better prepared, frankly, than I am to respond to those specific questions.
Okay. I think the point was well made that there's nothing in the Constitution currently that gives this right? Nor was it intended as Hiram Johnson had created the initiative process. So
this is more, rather than, I believe, a constitutional issue, it's really a regulation dealing with court procedure, the right to intervene in a court case, and those are routinely handled by statute rather than by constitutional amendment.
Very good. Do we have a motion?
I move the bill, please.
Bill has been moved by Senator Blakesley. Senator Harmon, certainly if you'd like to close.
I'll just ask for your aye vote. Thank you.
Okay, very good. We have a motion. Senator has closed his presentation. We'll take the roll.
The motion is due pass to the Senate floor. Evans? Harmon?
Aye.
Harmon, aye. Blakesley? Blakesley, aye. Corbett? Leno?
No.
Leno, no.
That bill is 2-1. We will place it on call. And we have one senator standing, one who's been seated for a while. I'm told Senator Liu is up next. Thank you, Senator Padilla, for your patience. So, Senator Liu, we have your item number 12, SB 757.
Thank you, Mr. Chair and Senators. This is a straightforward bill. Under existing law, insurers are required to provide the same coverage to domestic partners as they provide to a spouse. Unfortunately, some of the out-of-state insurers are not following this law. This bill closes that loophole. Respectfully request an aye vote. I have witnesses here.
Thank you, Senator. Those in support.
Mr. Chair, Mario Guerrero on behalf of Equality California. As was mentioned, the goal of this bill is to ensure that out-of-state insurers selling insurance in California abide by the same non-discrimination laws that California insurers must. California has established strong laws prohibiting discrimination among health insurers within the state. Existing laws require California-based insurers to provide the same coverage to domestic partners that they provide to spouses. SB 757 would clarify that any health insurance policy that is issued to or intended to cover any person residing in California must provide coverage for domestic partners that is equal to the coverage provided to a spouse and comply with all non-discrimination requirements in California law. While California-based insurance must already comply with this requirement, this bill would make it so that it also applies to any out-of-state insurance company providing benefits to California residents. We ask for your vote.
Ms. Turner, your support as well.
Yes, Ilona Turner, National Center for Lesbian Rights, in support of the bill.
Thank you. Anyone else in support? I don't see any listed opposition. Senator Liu, I see you're taking a similar approach to the way that San Francisco did some many years ago. I think it goes back to about 1996, when we were among the first local agencies to create an equal benefits ordinance. And in that ordinance, it was the concept of equal benefits for equal pay for equal work. Two employees sitting side by side should get the same benefits. The city, of course, did not require that there be any benefit. It was just that if a benefit was provided to a married partner, an equal benefit would have to be provided to the domestic partner. But again, no mandated benefit. So you're not mandating any benefit from any insurance policy. You're just saying that if there is one for a married partner, it'd have to be the same and equal for
that is correct.
Domestic partner. Very good. Any questions, comments from the committee? Would you like to close?
Respectfully request an aye vote.
I'd be happy to move the bill.
Thank you.
And we'll call the roll.
The motion is due pass the Senate Appropriations Committee. Evans? Harmon? Blakesley? Corbett? Leno?
Aye.
Leno, aye.
We have one vote. We'll put it on hold. Senator Padilla, your patience has been rewarded. Item number 15, SB 859.
Thank you very much. Thank you for saving the best for last.
Always.
This is SB 859. And let me just acknowledge that we continue to work up until the 11th hour with committee staff to craft amendments to this bill that I happily accept as author's amendments.
And I think those amendments are currently being passed out to Congress.
Yes, they're currently being passed out.
Thank you.
So just the context for the bill, and then I'll get to the specifics. We've heard not just in this committee, but even more so at the Energy Committee and in various discussions around the Capitol, the excitement around the deployment of electric vehicles in the country, especially here in the state of California. Experts predict that over the next 10 years, at least 1 million electric vehicles will be on the road. And there are a lot of people working diligently to ensure that the rollout is not only successful, from the perspective of the transportation point of view and the alternative fuel point of view, but from electrical grid reliability and stability point of view as well. Stakeholders include utilities, municipal governments, charging service providers, and many others. Again, working hard to ensure that as the electric vehicles are deployed throughout the state, that they integrate smoothly into the electricity grid. A key element of this smooth integration is the appropriate targeted information sharing between auto manufacturers, utilities, and the Department of Motor Vehicles, specifically so that utilities can ensure that the local distribution grid in the areas around the new owners of electric vehicles is capable of handling the increased load to that area of the grid. Up until recently, information had been shared on a census tract or zip code basis, helpful, but not enough for what the utilities need to do to run their diagnostics, determine if the grid is capable, and if not, making the appropriate upgrades to the electrical grid. So what is really, really needed here is address-specific information. Best area to obtain that information is the Department of Motor Vehicles that tracks electric vehicle purchases and even the resale of electric vehicles. Together with the amendments that we're taking, this bill would specifically provide that only address information be shared with utilities and not the names of vehicle owners. We seek to provide a clear, express disclosure to the electric vehicle owner that his or her home address is required by law to be shared with the utility. We provide that the confidential home address information disclosed pursuant to the bill may only be used for a purpose of identifying where an electric vehicle is registered and may not be used or disclosed for any other purpose or to any other person. And we ensure that only address information of the purchasers of electric vehicle is shared with the utility. Appreciate the chair and the staff's help in making a good bill even better and more focused. And I'm happy to introduce today Eileen Tutt from the Electric Transportation Coalition to speak on behalf of the bill.
Thank you, Senator Padilla. And I know that if Senator Evans were here right now, she would thank you very much for working with the committee and the staff to reach this agreement so that we could remove opposition. So welcome to your proponents.
Thank you, Eileen Tutt with the California Electric Transportation Coalition. And I definitely want to thank the chair and the members and the staff for working with all of us to amend this very good bill, as Senator Padilla said, and make it better. I want to clarify that the intent of the bill is very narrow now, very focused on what the information that the utilities need in order to provide safety, reliability, and efficiency of the grid. And I want to point out that the bill is a very, very important part of a three-pronged effort that CalETC and the Senator and members of the Energy Commissions, both the PUC and the CEC, have been working on to ensure that the utilities do have the information they need to hopefully make sure that our grid stays safe, reliable, and efficient. The automakers have participated in this effort, as have other stakeholders. But the DMV's role is critical because the automakers and the other big proponent of this bill or supporter of this effort is local governments, because when somebody buys a charger and they pull a permit, if the utility knows where that charger is, that's very helpful in helping the utility prepare for that additional load. But unfortunately, neither one of those data sets can capture the sale of a vehicle. So once a new purchaser sells a vehicle, that vehicle moves, and there's no way to track that except for the DMV data. So the DMV data really does represent the most comprehensive set set of address-level data available for the utilities. And we believe that the amendments that the staff and the members worked together on address all of the concerns expressed in the committee analysis, and we would very much ask for your aye vote. Thank you.
Thank you. Others in support?
Max Baumeffner with the Natural Resources Defense Council. Thank you, Chairman Leno. NRDC supports Senate Bill 859 because it will help support the successful integration of electric vehicles in California. These clean vehicles will provide the state with significant environmental benefits, create jobs, and reduce our dangerous dependence on oil. With these benefits in mind, the California legislature previously directed the California Public Utilities Commission to remove barriers to the widespread adoption of plug-in electric vehicles. Nearly all parties to the PUC rulemaking initiated in response are in agreement that providing utilities with timely notification as to the location of electric vehicles will reduce the costs of their integration and reduce the risk of service disruption for all customers. NRDC is also a member of the California Plug-in Electric Vehicle Collaborative, whose consensus report, Taking Charge, also notes and underscores the importance of the need for timely utility notification. As Eileen mentioned, Senate Bill 859 addresses one key pathway to ensure that this utility notification is provided. Accordingly, NRDC asks for your support of this important and timely bill.
Thank you, sir.
Heidi Barsili on behalf of San Diego Gas and Electric. We believe this is an important measure toward ensuring the safe, reliable, and efficient integration of the electric vehicle charging loads into our distribution system, and we ask for your aye vote.
Great. Thank you, ma'am. Others in support? I don't believe there's opposition, so if we have your name and identification, please.
Good afternoon, committee members. Rod Brewer on behalf of Southern California Edison, here in support.
Thank you, Mr. Burrows.
Russell Lowry on behalf of PG&E, here in support.
Thank you, Mr. Lowry.
Alicia Priego with the California Municipal Utilities Association, in support.
Thank you, Ms. Priego.
Excuse me. Erica Root on behalf of the Sacramento Municipal Utility District, in support.
Thank you. Anyone else in support? Any opposition? One question comes to mind. As we envision the greater proliferation of electric cars, and we eagerly await that phenomenon, might we see more and more people and more stations recharging at work as well as at home? Also imagining that there could be parking shelters with solar arrays on the rooftop so that the charge is all green as well. Would that need to be incorporated possibly at some later date, or are we thinking about that? Are there other places that people might charge other than at home?
Yes, and I was going to say I hope so, because one of the larger challenges for electric vehicle deployment is perception of range anxiety. Oh my gosh, what if I go to work? What if I'm shopping and I don't have enough, battery power to get home? And so there's going to be public charging stations, and there are mechanisms for utilities and others to know where those charging stations are installed, and therefore run the diagnostics around those distribution points to ensure that the grid is ready. No such mechanism exists for residential charging, and so that's the void that we're filling with this bill.
Right. Questions? Motion?
I applaud again the author for all the hard work on this bill. This is just an informational question I have. Can you help me? Obviously, we don't require similar information every time we put in a swimming pool or a freezer or other sorts of appliances that draw power. Presumably, this is because this draws so much more power than any other appliance that we currently have.
Right, no, that's the biggest difference. I mean, a swimming pool, even a refrigerator today versus a refrigerator of the past, a television today versus a television of the past may have a larger impact on the grid, but nothing comes close to the impact of an electric vehicle with the stage 2 charging station. You're talking about the equivalent of a small house.
And that was my question.
That's
very good.
Completely different scale.
And with that, I'd like to move the bill, if I may.
Thank you. Very good. So this is moved as amended. If you'd like to close.
I'd appreciate your aye vote.
Thank you. We'll call the roll.
The motion is due pass as amended to Senate Appropriations Committee. Evans, Harmon, Blakesley, aye. Corbett, Leno.
Aye.
Leno, aye.
Bill has 2 votes. We place it on call.
Thank you.
Thank you, Senator. Thank you for your patience. Senator Blakesley, the gavel is coming your way.
Thank you, Senator Leno. Item 10, please, SB 651.
Yes, thank you, Senator. Thank you, Mr. Chair. This bill, clean and simply, is a bill about equality. We have been circling the debate of marriage equality for many years here in California. Currently, we do not allow it, though 6 other states do. California was, I believe, the first to establish a domestic partner registry back in the late 90s. Year after year, we were able to add more and more benefits of marriage to our domestic partner registry. And I remember in 2003, I was able to co-author with then Assemblywoman Jackie Goldberg to just about bring all of the benefits, privileges, and responsibilities of marriage to domestic partnership, but not quite. And of course, we're not talking about the 1,000-plus federal benefits. When the Supreme Court ruled that it was unconstitutional to deny marriage licenses to same-sex couples, there was a response at the ballot box, and that was, of course, Prop 8. In upholding the constitutionality of Prop 8, our Supreme Court was very clear that given that California had a domestic partner registry, we were really arguing over, in the court's terms, a nomenclature. It was just a name. And given that it was just a name, that Prop 8 could be held as constitutional as long as all of the rights and benefits of marriage were provided to domestic partners. Otherwise, it was more than just a name, and there would be inequality and discrimination against those same-sex couples unable to marry and only able to access a domestic partnership. That is not yet the case in California. There is one issue which is addressed in this bill, which would bring us that one single step closer to equality. We all know about Britney Spears running off to Las Vegas to marry her boyfriend one night. They had no requirement that they had to share a domicile for 6 months prior to accessing that marriage license. It's an antiquated fact that when the domestic partner registry was established, that for whatever reason the legislature thought, well, let's just be on the safe side, very unfamiliar with the fact of same-sex couples partnering and having any legal benefits whatsoever under that scheme, require them to have 6 months of shared residence before we could issue a domestic partnership. This bill would repeal that, just as we have never had a requirement for shared residence for married couples. And there can be many reasons why a couple that is committed to each other and would like to get married if they could, but in this state allowed only a domestic partnership. For example, if it's a long-distance relationship, or if someone is caring for a parent and has a separate residence, or because of work obligations or study obligations. So there's no need to continue this requirement. This would bring us into compliance, closer compliance, with the Supreme Court's requirement that the difference be no more than just a name, and to provide equal legal protections, benefits to same-sex couples under the supposedly separate but equal domestic partnership registry. I'd ask for your aye vote.
Witnesses in support, please.
Good afternoon, Mr. Chair. Mario Guerrero on behalf of Equality California. We are a sponsor of SB 461 and thank Senator Leno for his leadership. As has been mentioned, important legal differences remain between domestic partnerships and marriage. And essentially because same-sex couples are prohibited from legally marrying in California, we are forced to pursue the enactment of legislation that will provide greater equality and security to domestic partnerships and to their families. However, I will point out that domestic partnerships will never offer the full dignity and protections of marriage. And so here we are today. I respectfully ask for your aye vote to move us one step closer towards equality for same-sex couples. Thank you.
Ilona Turner with the National Center for Lesbian Rights, also in support. Thank you.
Any other witnesses in support? Witnesses in opposition? Seeing none, questions or comments from the committee? Mr. Leno, would you like to close?
Yes, thank you. As I stated earlier, this is a simple matter of equality. There is no justifiable reason for requiring a higher hurdle for a domestic partnership than for a marriage license. I would ask for your aye vote.
Thank you very much. Do I have a motion?
Yes, glad to move it.
We'll call the roll.
The motion is due. Pass the Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Blakesley, no. Corbett? Aye. Corbett, aye. Leno?
Aye.
Leno, aye.
3-1. The bill will remain on call for the absent member. The only remaining bill we have, Mr. Anderson. There he is. Yeah.
I'd like to move the consent calendar, please.
Okay, we have a motion on the consent calendar. Call the roll.
Evans?
Aye.
Evans, aye. Harmon? Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
Consent calendar is 4-0. We will place that on call. Senator Anderson, item number 16, SB 903.
Thank you, Madam Chair, Senators. This measure is a follow-up to the California Public Divestment from Iran Act. And by the way, thank you, all of you, for your help in helping to make that become a law. Now, 3 years later, after the law was enacted, and a few oversight hearings later, we're still waiting for our public pensions to get the legislature's message and take divestment seriously. With Senate Bill 903, we add sunshine to the divestment process to assist CalPERS and CalSTRS with the full implementation of the law. With me to speak today is Cliff Berg from the Jewish Public Affairs Committee.
Thank you, Senator Anderson. Madam Chair, Cliff Berg here on behalf of the Jewish Public Affairs Committee, which represents all the Jewish federations, JCRCs, and other Jewish agencies in California. Also speaking here today on behalf of ADL, which sent a separate letter as ADL, which is a JPAC member. I want to thank you all again for supporting SB 221, which you passed 3 years ago, which required CalPERS and CalSTRS to identify those companies in their portfolios in the energy and defense sectors that had business operations in Iran, to report to the legislature on those companies, to take action to engage them to get out of Iran, and if they fail to do so within a specified time period, to divest. Unfortunately, CalPERS in particular has refused to divest from any companies. They identified roughly 20, all foreign companies, mainly foreign oil companies, that were doing business in Iran. It is illegal under U.S. law for any American company to be doing business in Iran. CalPERS in numerous oversight hearings and in response to letters to members of the legislature has basically said we will not divest because we believe any divestment action is a breach of our fiduciary duty and therefore will not do it. We have reviewed their determination of fiduciary duty and their analysis and believe that it is faulty and that it flies in the face of both common logic and the action of other states around this country like Missouri and Florida, which passed similar laws at the same time and have divested. Therefore, for the same reasons that we urge you to support 221, we urge you to support this, which is a modest measure which does nothing more than require CalPERS and CalSTRS to make their decision regarding fiduciary duty in a public hearing with public testimony with an opportunity for transparency and for sunshine to shine in. The problems in Iran that we talked about 3 years ago remain. The U.S. government and the United Nations are committed to imposing sanctions to stop their nuclear program and their development of a nuclear weapon which they threaten to obliterate Israel with. They remain repressing the democratic movement in their country, repressing gays, union members, women. It is a terrible regime. It is a terrible government. And this action is consistent with both the U.S. Congress and the United Nations. In fact, the Federal Iran Sanctions Act specifically exempts from liability pension funds for divestment actions. Would urge your aye vote.
Also with me, I have Barry Broad and Pete Conity to speak as well.
Madam Chairman, members, Pete Conity representing the California State Commanders Veterans Council, 22 veteran organizations, the American Veterans, and the Military Officers Association of California. And we are in support of this legislation as we were the original legislation because this is an American problem. If we don't stop Iran, we will be creating more veterans by having to go to war in the Middle East. If we don't stop Iran, the United States is the great Satan. Israel is the little Satan. So this isn't about Israel. It's about the United States of America. And those of us that grew up after World War II know about American companies that supported Adolf Hitler and didn't stop. And he could have, and everything I learned in history was he could have been stopped at any time along the way if somebody had just stood up to him. So on behalf of the 2 million veterans in the state of California, I would urge you to vote aye.
Very briefly, Mr. Broad, we have a member ready to make a motion.
Yeah, Madam Chair and members, Barry Broad on behalf of the Teamsters and the Machinists. And somehow in the analysis we were in opposition, but we're in very strong support. The Teamsters Union, the former CEO of CalPERS, Fred Buenrostro, remember him? He said, well, why don't the Teamsters divest from Iran? Well, God bless them, they did, and it took about 6 months. Their theory of why their fiduciary duty is somehow violated is because their theory is that on a mathematical formula, since they're invested in so many places, any time you sell stock, that you don't sell stock for exactly the reason of market placement is presumed to be a cost that is borne by the shareholders. That, however, flies in the face of the reality of daily life, which is, had you sold your stock in IG Farben on September 1, 1939, you would have been much better off than keeping it until 1945 when it was worth zero. Iran is a rogue state, and essentially we have a public pension plan that is standing in the way of democratic change in that country, our own country's policy, and the policy that this legislature unanimously voted for. We urge an aye vote. Thank you.
Thank you. And I do want to note the Teamsters are not mentioned as opposition in the analysis.
Oh, somebody.
It's okay.
Oh, somebody told me that.
We're real clear. Out. Teamsters are in support.
Okay.
All right. We have well, let me call and see if there's any additional witnesses in support. State your name, affiliation, and... I was asking for additional witnesses in support.
Okay.
Seeing none, I'll ask for witnesses in opposition.
Great.
Madam Chair, Berman Obaldea, representing CalSTRS. First of all, we want to point out that CalSTRS has been abiding by the tenets of AB 221. We have no direct investments in Iran currently. We have divested from 8 companies. We have restricted the 7 companies from the portfolio. We have brought on a third-party vendor to oversee and monitor those 7,000 companies that are under the CalSTRS portfolio. So we have been abiding by all the tenets of AB 221. The concern that we have with this particular piece of legislation is the fact that because of the reporting requirements, it opens up the what is heretofore private discussions on investments in a public forum, which could potentially have an adverse effect on the fund. Those are the concerns that we have currently with the bill. We're more than happy to work with the author, not only with Senator Anderson, but as well as Assemblymember Fuhr, who has a companion piece of legislation to try and address the need for transparency. And I might add, CalSTRS is at the forefront of transparency. We're the only pension fund that's on the web. You can listen to all of our meetings and so forth, visually as well as audially. We have all our postings on our website and so forth. How do we bring that transparency, but at the same time maintain the investment that has to be done in order to grow the fund? Bear in mind, this fund went from $175 billion to $113 billion as a result of the economic recession. Fortunately, we are back up to $150 billion. So that is a concern that we have in terms of how do you address the need for greater transparency, but at the same time retain our ability to make investment decisions in private pursuant to the Bagley-Keene Act. And those are the concerns that we're raising.
Thank you. Just to be clear, you have not submitted a letter of opposition, though.
We have submitted a letter of opposition to the Senate PERS committee where the bill was heard yesterday, but because of the timing, we weren't able to get that to you.
Okay, thank you. Any other witnesses in opposition? Comments, questions from the Assembly members? Senator Corbett? Oh, I say Assembly members. I'm sorry, I'm brain dead. Has it been moved? Do we have a motion? All right. Would you like to close?
I ask for an aye vote.
Thank you. We do have a motion. We'll call the roll.
The motion is due. Pass the Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Blakesley, aye. Corbett? Corbett, aye. Leno? Leno, aye.
Thank you.
4-0, the bill will remain on call for a few minutes to allow others to add on. Thank you very much. That concludes the bill presentations. We will now lift the calls on the remaining bills. We'll start with item number 1, SB number 5, Harmon.
Evans?
No.
Evans, no. Leno? No. Leno, no.
Item number 1. That was item number 1.
Corbett? Corbett, no.
That bill's 2 ayes, 3 noes. The bill fails. Item number 2, SB 326 as amended. The vote currently is 4 ayes, 0 noes.
Blakesley?
Harmon was an aye on SB 326.
Blakesley, aye.
The bill is out, 5-0. Item number 4, SB 382. Currently, the vote is 3 ayes, 0 noes. The chair was an aye, and the vice chair was an aye.
Blakesley? Blakesley, aye. Leno? Leno, aye.
That bill is out, 5-0. SB 422, Wright. The vote is currently 2 ayes, 0 noes. Both the chair and the vice chair are ayes.
Blakesley? Aye. Blakesley, aye. Corbett? No. Corbett, no. Leno? Leno, aye.
That bill is out, 4-1. Item number 7, SB 495, Fuller. Currently, the vote is 3 ayes, 0 noes. The chair has not voted. The vice chair has voted aye. Call the roll.
Evans?
Aye.
Evans, aye. Blakesley? Aye. Blakesley, aye.
That bill is out, 5-0. Item number 8.
Yeah, you made the motion.
Item number 8, SB 599, Senator Keogh. Currently, the vote is 3 ayes, 0 noes. The chair has not voted yet. The Vice Chair has voted aye.
Evans?
Aye.
Evans, aye. Corbett? Aye. Corbett, aye.
That bill is out 5-0. Item number 10, SB 651 Leno. Currently the vote is 3-1. The Vice Chair has not yet voted.
Harmon?
Not here. We'll put that back on call, awaiting the Vice Chair's arrival. Item number 11, SB 708 Corbett. Currently the vote is 2-1. The Chair has not yet voted, and nor has the Vice Chair.
Evans?
Aye.
Evans, aye. Harmon?
That is currently 3-1. We'll place it back on call for the Vice Chair to add on. Item number 12, SB 757 Liu. Currently the vote is 1 aye, 0, well, has 1 aye vote. Chair and Vice Chair have not yet voted.
Evans?
Aye.
Evans, aye. Harmon? Blakesley? Blakesley, no. Corbett? Leno? Oh, Leno, aye.
Item number 12.
Corbett, aye. That's 3.
Excuse me, the vote is 3-1. We will place it on call for the Vice Chair to add on. Item number 13, SB 761 Lowenthal. Currently the vote is 2-1, and the Vice Chair has voted no, and the Chair has voted aye.
Blakesley? Blakesley, no. Leno? Aye. Leno, aye.
3-2, that bill is out. Item number 14, SB 848 Emerson. The vote is 1-3. The Chair voting no, and the Vice Chair voting aye.
Blakesley? Aye. Blakesley, aye.
The bill fails 3-2. Excuse me, 2-3. Item number 15, SB 859 Padilla. The bill currently has 2 ayes. The Vice Chair and the Chair have not yet voted. And the amendments were taken by the author.
Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Corbett?
Excuse me, I'm sorry, Madam Chair. We're voting on 15 or 16?
15.
15.
Senator Padilla. He took amendments which removed the opposition.
Could I just pass on that? Harmon, aye.
Harmon, aye.
The bill has 4 aye votes. It is out. Item number 16, SB 903 Anderson. The Chair has voted aye and currently has 4 aye votes.
Harmon? Aye. Harmon, aye.
That bill is out 5-0. We'll go back and call the other bills that are on call. SB 651 Leno.
Harmon? No. Harmon, no.
That bill is out 3-2. SB 708 Corbett, item number 11.
Harmon?
Could I inquire the current vote?
It has 3 ayes, 1 no.
Harmon, no.
Harmon, no.
That bill is out 3-2. SB 757 Liu, item number 12. The current vote is 3 ayes, 1 no.
Harmon?
Item number 12, SB 757 Liu.
No.
Harmon, no.
The bill is out 3-2. Consent calendar, currently it has 4 ayes.
Harmon? Harmon, aye.
The consent calendar passes 5-0. And that concludes the business of the Judiciary Committee today. We are adjourned.